I'm Jeb Butler, and this is Matt Kahn. We're lawyers at the Butler Kahn law firm. Wanted to talk today about $7.8 million. That's not a settlement, and that's not a verdict. That is what was added to the verdict in a car accident case that we tried in April. So we tried the case, got a $28 million verdict, and then through some procedural work we did, we're able to collect fees and interest and add another $7.8 million to the total judgment. What's this case about to begin with?
Sure. So we actually have another video on this that includes a really cool animation. So be sure to check that out. But basically, this was a car wreck case, head-on collision. Our client was heading home after doing something nice for his family. He had installed a grill at his ex-wife's house for his family to use and was heading home. And another driver just erratically crossed over the center line and unfortunately killed Mark Cohen. And so we represented his family who took the case to trial.
Well, who's in this picture behind us?
Oh, there we've got a picture. That's Mark and his daughter, Emily.
After her graduation, obviously. Okay.
Yeah. So, Jeb, why don't you walk us through sort of what an offer of settlement is?
Yep. All right. So we did two different things to get to that 7.8 number. The first was an offer of settlement, sometimes called a Rule 68 offer. So the Georgia legislature, actually acting at the behest of the tort reformers, that is the insurance lobby, passed about 20 years ago this rule that said if you make an offer on a case and then if you're the plaintiff, you beat that offer by a certain amount, or if you're a defendant, the resultant judgment is less than that offer by a certain amount, you can make the other person pay your attorney's fees. Now, the design of this rule, the reason they did it was supposedly to prevent frivolous litigation because people would be afraid of the fees. Well, it turned out that plaintiffs weren't bringing frivolous cases to begin with because no plaintiff's lawyer would do that because it would be a terrible business practice. But what was happening is that insurance companies were frivolously denying liability and refusing to pay claims that they should. So what it means for our purposes, since we represent plaintiffs, people who've been hurt and their families, is that we can make an offer in a case to settle for a certain dollar amount. And if we end up with a judgment from the court, usually after a trial and a verdict, a final judgment that is 125% of that offered amount or more, then we get to collect our attorney's fees. So here, what we did was fairly early in the case, let me get my numbers right, we made an offer to settle the case for $6.3 million, which we would have been a little surprised if they'd accept it because it was early in the case, but it was a fair offer because it was a clear liability case and because this fine man had lost his life, and $6.3 million reflected only his economic losses, not the huge non-economic losses associated with the case. And the defense turned us down. So then when we got to trial, got a $28 million verdict. We have beaten the offer by well over 125%. Actually, we beat it by more than 400%. So we were able to collect our attorney's fees and interest. The attorney's fee is our contingency fee. That is our percentage of the case. We don't charge exorbitant fees, so we're able to show to the court that our fee was a reasonable one and that it was a valid indicator of the work we'd done. And that meant that the court said, yeah, I'll award you fees. So that added $6.3 million to the judgment. But that's not the entirety of the story. That didn't get us to 7.8. What else we got?
So, Unliquidated Damages and Interest Act, our favorite statute. We call it UDIA for short. But basically, this is a statute under Georgia law that allows any party to send a demand, and if they exceed that demand at trial, then you can collect prejudgment interest on the amount demanded from the time of rejection through the entry of judgment. And this is a really powerful tool in Georgia because the amount of the interest that is added on is the prime rate plus 3%. And so at the time that we tried this case, and sent these offers, the prime rate was 8.5%, which plus 3 is 11.5%. That's a lot of interest, and pretty much just about, I'd say, the best of investment you can make. But so after the defense rejected our $6.3 million Rule 68 offer, we sent one that we envisioned being closer to the actual value of this case. So we sent one for $25 million. The defense, of course, rejected that. And then because our verdict and final judgment ended up exceeding the $25 million that we demanded, we were entitled to prejudgment interest on that $25 million from the time early on in the case when the offer was rejected all the way through the entry of judgment. And so here that added up to be about $1.2 million that got tacked onto the final judgment in addition to the $6.3 million of attorney's fees.
So we like to have something to show rather than just our beautiful faces. And there's not really good pictures for this, but here's a picture of the judgment entered by the court. And you have to do it in this sequence. You do the Damages Interest Act first. So here you can see these got our $28 million compensatory verdict number 1. That was the verdict, and then we added the $1.2 million there under the Unliquidated Damages and Interest Act, and then number 3 is the post-judgment interest that Matt was talking about, $9,200 a day. And then I talked a little bit earlier about what we call Rule 68, or the offer of settlement statute, and here is the court's order on that, adding the $6.3 million. So anyway, a good trial, great clients. The person who lost his life was really a great man, and we're happy to be able to have worked for him, even if posthumously. I guess if there's a moral to the story, it is use the Tort Reform Act against them. Send a Rule 68 offers when you have an insurer who won't pay what it should.